Welcome to this session on the Sexual Harassment of Women at Workplaces, Prevention, Prohibition and Redressal Act 2013. This is a very important piece of legislation. It has got a lot of prevalence and importance. This one, as you know, the women of sexual harassment of women, it is not today, it is even an age-old story. Even in our ancient mythological stories, like even Ramayana and Mahabharata, we have heard of the women's sexual harassment. Even Draupadi was not spared, even Sita was also not spared. This is the state of affairs. Now, is the safe working place for a woman is a legal right. Indeed, the constitutional doctrine of equality and personal liberty is contained in Article 14, 15 and 21 of the Indian Constitution. This article ensures personal right to equal protection under law, to live a free life from discrimination on any ground and to protect life and personal liberty. In fact, this is further reinforced by Union Convention in the UN General Assembly in 1979, and which is ratified by India also. And often it is described as an international bill of rights for men. It calls for equality of men and women. Sexual harassment constitutes gross violation of women's rights to equality and dignity. It has got roots and is attained perception that men are superior to women, and some forms of violence against them is taken as very natural. Because we are men, yeah, we do this. This is quite natural. And one of these is workplace harassment, which use various forms of such harassment, and many times it is all harmless and trivial. Often it is excused as is a natural male behavior. It causes serious harm and also strong manifestation of sex discrimination at workplace. So it is an infringement of the fundamental rights of women under Article 19 of the Constitution. In India, there was no legislation to deal with such cases of sexual harassment of women at workplaces. Of course, our Indian Penal Code has provisions of molestation, rape, assault, etc. is there, but there is no specific law to deal with such situation at workplaces. It was not there. Until such time, in 1998, the Supreme Court intervened in this case and came heavily on this particular issue. Then the government has enacted this act, which has come into effect from 9 December 2013. The background of this, I'll just tell you in 2 minutes time. In 1992, in Rajasthan, a lady called Banwar Devi was engaged by the Rajasthan government as a friend to go and then prevent child marriages in the region. In fact, she was very instrumental in stopping the child marriage of a 1-year baby, and she stopped the marriage at a remote village in Rajasthan. This was resisted to by the local people, but she still went ahead and stopped the marriage and saved the girl. On account of this, the local people got enraged and they gang raped her. Then afterwards, of course, the sequences followed. The police complained and the magistrate and everything, it went on, but she did not win the case, and all the cases were in favor of those people, not in the favor of that lady. Including the High Court of Rajasthan, her case was not being successful. Then this was observed by one NGO in Delhi called Vishaka. They were tracking the case, and then they filed a public litigation application before the Supreme Court of India. Then Supreme Court heard the case in detail and came very heavily on this case. This is called the famous case of Vishaka versus State of Rajasthan. Here in this case, the Supreme Court came very heavily on this case, and they said that sexual harassment of women at workplaces is completely violative of articles under fundamental rights and articles of Constitution of India. Hence, this cannot be tolerated, should not be tolerated anymore. And they immediately directed the central government, to formulate the suitable legislation without delay. And in the meantime, the judgment itself, they provided a series of guidelines to employers, and they directed thus these guidelines shall be followed by the employers strictly hereafter. Till the Parliament enacts a law, this judgment, this guidelines enunciated in this judgment shall be the law of the land till the enactment comes. And any violation by any employer will amount to contempt of court, and they will be punishable under the law. And they also suggested various guidelines. The guidelines included that it is the responsibility of the employer to declare a policy to provide a safe working condition for women in his employment. And an internal complaint committee should be constituted with representative of male and female officers to the company, and the chairman shall be the one of the senior women employee, and an outsider for an NGO who is specialized, has got expertise in the area of women rights, shall be in the meeting, and any such complaint shall be heard by the internal committee, and recommendation must be given to the employer to take suitable steps in this matter. In the meantime, the government court also directed that the suitable modifications of amendment to be brought in the service conditions of every employer, or even the standing orders, to incorporate the acts of sexual harassment as one of the misconducts, either in the standing orders or in the service conditions, service rules, whatever they have. So this is the landmark judgment which has turned into a major issue like this. Now, arising out of this, the Act has been promulgated. Now, let me take you what the Constitution may say rights of women. You can have a look at the slide, which gives you very clearly. Article 14, it gives right to equality. Article 15, right to non-discrimination. Article 16, right to equal opportunity in employment. Article 19(1), freedom to practice any profession and to carry out any occupation or trade or business. Article 51A, it is the duty of every citizen to abide by the Constitution and respect the ideals and institutions. Article 21, right to life. Article 51A, the state shall denounce the practices that are derogatory to the dignity of the woman. This is the Constitution says. So it has to be taken into account that any action by state government should ensure that these things are taken care of. Now the Act, it has got a applicability is very wide. It covers all places of engagement of irrespective of the number as well as any activity or business. So it has coverage everywhere, wherever employment is there, it covers. And even domestic also is covered, but of course authorities are different. But even domestic also is covered under this Act. It includes all women, that's what he said. All women, whether engaged directly or through agent, includes a contractor with or without on the principal employer. They will be working for remuneration or on a voluntary basis, even otherwise. Their terms of employment can even be expressly implied or even expressed. So, you look at this, it has got a very, very wide implication. Further, she could be a co-worker, a contract worker, a probationer, a trainee, an apprentice, or a student, and you can be called by any such a name. The Act also covers a woman who is working in a dwelling house, in a house or a place. It covers that also. As per the Act, worker includes everything, either the government organizations, private sectors, then hospitals, nursing homes, sports institutes, facilities, places visited by employee, including while in traveling, including transportation provided by employer, a dwelling house or a home. Then the Act defines unorganized sector as like this. An enterprise owned by individual or self-employed workers engaged, this is unorganized sector. An enterprise which employs less than 10 workers is called a broadly unorganized workers. Because for instance, if you employ a domestic maid in the house, she comes into the unorganized sector. And if an enterprise employs less than 10 people, it comes under unorganized sector. This is for the purpose of classification, that's all. An employer refers to head of the department, any person who is responsible for management, supervision, control. A person in the household who employs benefit employment domestic worker, a person in the household, he is also included as an employer. Then the state government shall notify the district officer. He can notify a district magistrate or additional district magistrate or collector as a district officer. So look at the status of the district officer. He should be a district magistrate, additional district magistrate or collector or deputy collector. So the high level is given at the local level. The district officer will be responsible to carry out the powers and functions under the Act at district levels, including every block, taluk, district ward, etc. Under the law, the employer or the district officer is obliged to create a workplace free of sexual harassment. So it is the responsibility of the employer to in general to create and communicate a detailed policy. For instance, in the company also we had to ensure that the policy create and then make aware of the people. Ensure awareness and orientation of the issue. Constitute complaints committee in every workplace or district where women are provided with mechanism of redressal of the complaints. Ensure complaint committees are trained with both and skill and capacity. This is very important. The complaints committee, the members who hold this, they should be trained both in skill and capacity as to how to inquire into the matter. That's very important. Then prepare an annual report and report to the respective state government. District officer also will do the same thing. He will appoint a nodal officer to receive the complaints at the local level. The complaint, two kinds of complaint mechanism. One is the internal complaint committee and another is the local complaint committees. Now first of all, internal complaint committee. You look at this slide and you know every employer obliged to constitute an internal complaint in a written order. The essays will be composed of the following. Chairperson shall be the women working at senior level of an employee. If not available, then nominated from other office or units of the department workplace the same employee. The important thing is that the chairperson shall be a senior women employee. 2 members minimum from amongst the employees committed to the cause of women are having legal knowledge or experience in social work. Then member from amongst the NGO or association committed to the cause of workmen, they should be there. Where the office or administrator has got located different places or different subdivisions, the internal complaint committee has to be set up at each administrative unit or office. It's not one is enough. Each unit has to have its own complaint committee. Then local district committee. It is constituted like this. Please have a look at this slide here. A chairperson nominated amongst the eminent women in the field of social work and committed to social cause. This is appointed by local committee by the district magistrate. Member nominated from amongst the women amongst the block, taluka or tahsil or ward or community, municipality in the district. Then 2 members nominated from amongst the NGOs, associations, the person committed to the cause of women are familiar with the issues related to sexual harassment, provided that at least one must be women. One must have knowledge of background of law and legal knowledge. So these are the conditions. Ex officio with the concerned officer dealing with social welfare or mental welfare in the district shall be the ex officio member. Then the Act refers to external complaint generally means the complaints who have expressed the issue of sexual harassment. So this is extremely important, and the attributes are demonstrate knowledge of skill and capacity in dealing with the workplace of sexual harassment issues, sound grasp of practice of the legal aspect and implication. This is very important, and it is the responsibility of the employer or the district officer to ensure that the members of these companies are trained accordingly. Then what are the employer's responsibility? Number 1, the publication of the policy on the subject. orientation programs and seminars for the members of the committee, carry out employee awareness programs, conduct capacity building and skill building programs for the members of the committee, declare names and contact numbers of all members of the committee prominently on the notice board, use modules developed by state government to conduct workshops, etc. These are the primary responsibility of principal employer. Now, what are the acts that constitute sexual harassment? The act defines any welcome acts of behavior directly or by implication, including physical contact or even advances, a demand or request for sexual favors, making sexual colored remarks, showing pornography, or any other welcome physical, verbal or non-verbal contact of sexual nature. So anything and everything is added in this case. When implied or explained promise of preferential treatment in employees, this normally happens at the time of recruitment, at the time of promotion, at the time of transfer, at the time of deputation. This can happen. I will give preference or info. Okay, I favor this, you give me this kind of thing. When implied or expressed threat of discriminated treatment of employment, I will transfer you to some other place, I will transfer some other department, this kind of thing. Implied or expressed threat about our present or future employment status. You know, I think I have to take care of you, I have to sack you, I have to transfer, this kind of thing. Intervene in the work or creating, intimating, offensive or hostile work environment for her on someone. Humiliating treatment likely to affect her health and safety. All these things constitute harassments. Harassment can be physical or even hostile environment, verbal, non-verbal, or even sexually colored remarks or even visuals. All these things are treated. Of course, these types of sexual harassment is quid pro quo, in the sense that saying that something for something. So this normally it happens in a workplace, and this is to be needed to be attention. The hostile environment, where the environment is created where a superior colleague or says things are uncomfortable or offensive to person as an individual. You know, environment can be created anything. So one of the two is not interested in relationship or desire to terminate a relationship, but the other uses unequal terms and conditions of employment to workplace to further relationship, but must to, they create a hostile environment in various things, and the women employee will be at harassment. This is also a type of sexual harassment. Physical contact is already told you about all these things. Then relationship advances, repeatedly asking for a date or relationship. Pretext of bad marriage or weak spouse, etc. Winning sympathy. All forms, indirect, direct forms are all can be colored as sexual harassment, and women can definitely come out with complaint, and the complaint has to be taken into account. Non-verbal, it can be even staring, it can be leering, lewd gestures, winking, dirty looks or gestures, all things will happen. Verbal, it can be jokes, it may be comments, requests for dates, generally abusing the other gender, passing objectionable remarks, insulting jokes, dirty expression about someone in the absence. All these things constitutes the acts. When unparliamentary use of language, dirty expressions, insulting jokes, offensive comments, showing pornography, degrading drawings, notings, letters, poems, faxes, pictures, folders, danglers, cartoons, streamers of sexual, whatever it is. The factors leading to sexual harassment are normally it is isolated, secluded, picnics, parties, excursion, and marriages. These are the things where normally it happens. Positions are normally it is junior to senior, temporary, permanent, or contractual workers. Persons can be individualistic or even can be group. Now here, in one of the case, in 2010, the High Court of Delhi came out with a very, very novel judgment. They say sexual harassment is a very subjective experience. We therefore prefer to analyze the harassment from the compliance perspective. Here, men may tend to view some form of sexual harassment as harmless social interaction which only sensory women would object. That's what people said. The court said, these are the things what in society you have to see objectively and then appreciate the mental agony and woman undergoes, and then the violent pursuit. This is judgment that's given in this particular case. Now, who can complain and where? If you look at this slide here, you can see I have prepared a small table for this. In case of physical disability, complaints, relatives can give a complaint. Complaints friend can give a complaint. A co-worker can give a complaint. A member of a National Commission for Women and State Women Commission, they can give a complaint. Or any person who has knowledge of the incidents with consent from, they also give a complaint. So there is a wide opportunity been given to give a complaint. In the case of mental disability also, a lot of things have been created. It is said that complaint relative or a friend, they can give a complaint. Special educator, qualified psychiatrist or a psychologist, a guardian or authority under whose care she is receiving treatment. Any person who has knowledge of the incident jointly with the both, they can give a complaint. In case of complaints death, any person who has knowledge of the incident with written consent from legal heirs, they can give a complaint. In case the complaint unable to file for any reason, any person who has got a knowledge of the incident with consent agreed, they can give a complaint. So it is a wide opportunities have been given so that the women they definitely complain, and any handicap is not an excuse, they can give it. Then six copies of the complaint to be filed along with all the documents. Then the manner of inquiry. Here the manner of inquiry, one copy of the complaint will be sent to the respondent within 7 days. The respondent to submit his reply in next 10 days. The complaint committee start inquiry into the incident in line with the principles of natural justice. When parties are not allowed to be represented by a legal practitioner, this is one important thing. During inquiry, minimum 3 members of the committee, including chairperson, shall be present. Then preparation of annual report. It has to be done, number of complaints in a year, number of complaints disposed of during the year, and then cases pending for more than 90 days, the number of workshops and awareness program carried out, and nature of action taken by employer, the annual report has to be followed. The penal provisions are very, very severe. He said any contravention of any of these provisions, the penalty will be 50,000 rupees on the first go. Repetition of offence would result in not only double, but it can deregister the organization. It means that if you got a factory license, it can be withdrawn. If it is a shop and commercial establishment, that can be withdrawn. That is the power given under this provision of law. Now here, the role of HR, particularly here, is very important, particularly in the recruitment process, in the matter of increments and promotion, in the matter of transfers and deputation, and cases of unusual grant of advances of money, personal performance evaluations, deputation for skill development programs. And in these areas, the human resource management had to look into very with a microscope to see whether anything is happening, because these are the places where the sexual harassment can. So preventive steps can be taken by HRM by applying their mind in this area of the entire operation. So thank you.